Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hi, everyone.
Now, Dennis, I noticed that there's a helpful visual in last week's bulletin on the recent elections and the change for the authorities concerned in respect of administrations and no overall control. Now, for anyone concerned about navigating changes, take comfort from the words of Jonathan Carr West from the Local Government Information Unit, who recently reminded us in his blog that local government has the systems, the checks and balances, and the professional staffing to make this work. That's partly about the nature of delivery in local government. As people enter new leadership positions, they will discover that the room for manoeuvre is limited. They are constrained by funding, by statutory obligation, and they need to work collaboratively with other parties, with other public sector institutions, and indeed with communities. They are also likely to experience a sharp encounter with the realities of SEND deficits, the social care funding gap, and the ever-lurking threat of judicial review. Driving service transformation, navigating reorganisation, and steering towards financial sustainability will be challenging and necessitate a very steep learning curve. Sage words indeed from Jonathan. Now then, Dennis, let's take a walk through the bulletin, and we are sticking with elections first.
Indeed we are, Helen. You may remember that we have previously highlighted that there is a special conference known as a Speakers' Conference established through Parliament to look at the conduct of and behaviour at elections. The May elections were also marred in some areas by similar reports of misconduct of the kind we have seen many times before and has become sadly part of our British political culture. Now, last week, the Committee on Standards in Public Life published its own submission to the conference, and we look here at some of the highlights of what they said. And the first question they addressed was, what factors influence the level and nature of threats targeted at candidates and MPs? The committee found that intimidation has been experienced by all groups across public life and the political spectrum. However, as they noted in paragraph 8 of their detailed submission, much of this abuse was targeted at certain groups. Specifically, the committee found that candidates and MPs who are female or from ethnic minority backgrounds or LGBTQ+, and these were disproportionately targeted in terms of scale, intensity and vitriol, and that the intimidation experienced by those with intersecting identities was even worse.
Well, looking at the drivers of these behaviours, the committee said they also heard significant evidence of intimidation which is motivated by prejudice or hate towards an individual's gender, race, religion or sexual orientation. This was exacerbated, the Commission said, by those in public life setting a derogatory and abusive tone for political debate, which engenders prejudice or hatred towards individuals or groups and creates a context in which others feel it is appropriate to engage in intimidatory behaviour.
And another question that the committee addressed was, are there any changes to electoral law that would help strengthen the security of candidates and democracy more widely? Now, the submission drew attention to the committee recommendation back in 2017 that the government consult on the introduction of a new offence in electoral law of intimidating parliamentary candidates and party campaigners. The government consulted on this back in 2018. The Elections Act 2022 introduced a new penalty for people convicted of intimidation when the intimidation is directed at candidates, campaigners or elected representatives, called a disqualification order. Now, anyone found guilty of this behaviour could be banned from standing for elected office for 5 years, and the committee said that they welcomed this significant legislative change. Now, there's far more detail in the bulletin posting on all of this. It can be found in Bulletin 18 on the LLG's website.
Well, leaving elections behind, let's look at a case that should serve as a warning to all of us, especially in legal proceedings. Now, this is a widely reported case across the sector, Dennis. I believe the bulletin flags the Law Gazette article, but it has been reported in numerous places. So the High Court has ordered that a barrister and instructing solicitors should be reported to their own professional regulators following the reliance on 5 completely made up case law citations within the statement of facts and grounds for judicial review. Now, transcripts of the judgment were ordered to be sent to both the SRA and the Bar Standards Board. Now, Mr. Justice Ritchie's sitting said that the behaviour of the barrister and the lawyers at Haringey Law Centre in London had been improper, unreasonable and negligent, and he also ordered them to pay wasted costs in favour of Haringey Council.
Well, that's right, Helen, and matters probably weren't improved before the judge when the copies of the cases could not be presented, and made worse by the solicitor's reference to them as minor cosmetic errors. Now, you might be thinking, Helen, that it's quite harsh for the solicitors in this case, relying upon the professionalism of the barrister to be held to account for these non-existent cases. But let's not forget that solicitors cannot exempt themselves from their professional duties to ensure that the contents of submissions are correct, rather than be absolutely shocked and potentially outraged at the use of the made-up cases. The judge himself could not understand why the solicitors were not shocked when they found out.
Well, that's right, Dennis, and things got a little bit more complicated around how these made-up cases came to be used. Now, Haringey's Council's barrister proffered the explanation they were made up by the use of artificial intelligence. However, the judge decided that he could not make that finding because the barrister concerned had not been sworn in to give evidence. However, the judge wholly rejected the explanation that they were taken from a case box or a list of cases with ratio, which had been dragged and dropped into the documents. And indeed, Mr. Justice Ritchie was very clear about this. In the judgment, he said, and I'm quoting him here, "I do not understand that explanation or how it hangs together. If she herself had put together, through research, a list of cases and they were photocopied in a box, this case could not have been one of them because it does not exist. Secondly, if she had written a table of cases and the ratio of each case, this could not have been in that table because it does not exist. Thirdly, if she had dropped it into an important court pleading for which she bears professional responsibility, because she puts her name on it, she should not have been making a submission to a High Court judge that this case actually ever existed because it does not exist." Dennis.
Fascinating case. I'm glad you flagged that one, Helen. Let me turn now to an aspect of the local government review, which has been worrying many, and it's a question of whether the government will provide financial support to local authorities. Now, the government has confirmed it will provide financial support to help reduce working borough councils' debt ahead of local government reorganisation in Surrey, and the council has revealed this itself. Whitehall has also agreed to assist the council and any new unitary authorities created through the reorganisation process, with the rationalisation of Woking's assets, according to a report set to be considered in an extraordinary council meeting in Woking Council. Concerns about how Woking's £2.1 billion debt could impact reorganisation were first raised in January, when Surrey County Council's leader suggested that the government write off all the council debts. In a letter to the government, Councillor Tim Oliver said at the time such a move could help tackle the unique, significant financial risk of the level of debt currently held across the Surrey local government footprint.
Well, meanwhile, the County Council's interim proposal for reorganisation, which was submitted in March, I believe, described writing off Woking's debt as a key ask to enable the success of reorganisation. And while Woking's £2.1 billion debt will not be written off, the government has committed to providing an initial tranche of financial assistance to support repayment of the debt in 2026-27 prior to reorganisation, according to a council report.
Well, the government has said that it will also provide further interim financial assistance and commercial expertise where necessary. Leader of Woking Borough Council, Councillor Anne-Marie Barker, said, "We welcome the government's statement of intent regarding future financial support. It marks an important step towards addressing our debt position as part of wider discussions on the future structure of local government in Surrey.
Well, let's turn our attention to the Planning and Infrastructure Bill now. Incidentally, the Northern Regional meeting last week had a presentation on planning from Trowse and Hamlins, which is available to watch on demand on the website. So let's look at the Office for Environmental Protection. Now, they've said that the provisions in the forthcoming bill are, quote, a regression. Dame Glenys Stacey, who's the chair of the OEP, said that, quote, we recognise government's ongoing commitment to nature's recovery, which will be so vital to meeting the Environment Act's legally binding targets, the first of which fall due within the next few years. Our latest assessment of government's progress found it is largely off track to meet its legal environmental commitments. And Dame Stacey also said, we are concerned by several aspects of the bill which undermined its potential to deliver the intended win-win outcomes. That's a phrase the government uses quite a bit in relation to the bill. There are fewer protections for nature written into the bill than under existing law. Creating new flexibility without sufficient legal safeguards could see environmental outcomes lessened over time.
Well, in a letter to the Secretary of State for Housing, Communities and Local Government, Angela Rayner, the watchdog said much of what the bill is seeking to achieve would be beneficial, but raised fears about diminishing environmental protections. The organisation welcomed the proposed join-up between environmental delivery plans and both the Environmental Improvement Plan and local nature recovery strategies.
There's so much going on in this bill. Well, the Office for Environmental Protection has said that the situation is not unresolvable. Within its advice, it sets out how the reductions in legal protections for the environment in the proposed approach can be ameliorated to a large part. This, it says, would make a material difference to the prospects of government achieving more for nature, whilst also streamlining and speeding up planning decisions. Now then, Dennis, something a little quirky now, I feel.
Well, I think it is. People have been spitting feathers in the New Forest District Council over this one. Subjecting your neighbours to early starts is nothing to crow about, the owner of a cockerel has discovered to his cost. Harold Brown has been fined nearly £4,000 after his neighbours cried foul over his rooster shaking its tail feathers from 5 o'clock in the morning, every morning for years. New Forest District Council found the bird created unacceptable levels of noise that disturbed the sleep of the community, and the ruling followed initial complaints from 8 households living near Brown's home in Hampshire in October 2022. But despite being served with an abatement notice in December that year, Brown refused to make his chicken fly the coop. Instead, the bird continued until further complaints from 12 households in 2023. Brown was prosecuted and convicted in November 2024.
Well, Brown did subsequently appeal against the conviction, but his case has just been dismissed at Southampton Crown Court, with Brown sentenced to £200 in fines, legal costs, and this is going to hurt, of £3,651, 95 pence, very precise, and in what neighbours consider to be a particular feather in their cap, an £80 victim surcharge. Now, a council spokesman said the diary evidence kept by local residents highlighted that the crowing regularly affected their sleep from as early as 5 a.m. each day.
Shocking. And Dan Poole, a councillor responsible for community safety and well-being, said, "We're committed to protecting our residents from unacceptable levels of noise and supporting them when issues arise. Everyone has the right to the peaceful enjoyment of their home. And when informal approaches fail, we will not hesitate to take legal action where necessary." Well, Helen, well, wait for it. The residents must be cock-a-hoop.
Can I just apologise to every listener for the references in that? They were quite impressive, Dennis, I thought.
Thank you.
But we do need to get on. And I think perhaps, Dennis, you've missed your vacation. You should be on Have I Got News for You or something like that.
I'll put the application in straight away, Helen.
Do so, I'll support it. Um, Now, the final item for today is the news that the Civil Justice Council has recommended a single unified digital court should be created for enforcement of judgments, despite whether it's given in the High Court or a county court, with all debts recorded, including those falling outside the courts. Now, this is among 39 recommendations to reform the enforcement process by the council in their report simply entitled Enforcement.
Well, Helen, the aim of this Civil Justice Council report is to consider ways in which the enforcement of judgments can be made more effective and efficient in both time and costs, while ensuring the essential protections for vulnerable defendants, particularly with the growing problem of household debt. The report therefore includes both recommendations for practical changes, which can assist in making enforcement more effective and fairer.
Well, the council does recognise that significant further work is needed, and they've set these out. It includes ascertaining how the digital enforcement court would operate, including any legislative or regulatory changes and changes to the CPR, considering enforcement in the property sphere and extra jurisdictional enforcement. I like that word. And investigating further whether there should be a system change from the current court-centric model to an administrative or judicial officer model. Now, recommendations for consideration by the MOJ and Her Majesty's Courts Tribunal Service and other relevant government departments include the fact that funding should be increased for debt advice organisations to allow for more advice at an early stage, increased engagement of defendants and increased resolution at an earlier stage, thereby, they say, removing economic drag and adding to growth. The council says the MOJ should facilitate the sharing of best practice guidance between debt advice agencies, that funding should be provided for the provision of a telephone or web chat advice service with debt advice agencies, both at the commencement of proceedings and as an advice service at court, and that information about debt advice, including telephone and electronic contact details, should be publicised through the display of a standard poster or electronic equivalent in each civil court building and in other public buildings that provide contact information. And by here they mean things like GP surgeries, hospital waiting rooms, employment centres, libraries, etc. Now, the 70-page document is available by link in the bulletin. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 18, available on the LLG website now. So it's goodbye from me.
And from me too. Bye now.